Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1007. Gemi Spaulding et al. Petitioners versus Merrick v. Garland, Attorney General et al. Mr. Flannery for the petitioners, Ms. Gay for the respondents.
Mr. Flannery?
Yes, ma'am.
Good morning.
Good morning, Your Honor. I think you were warm today. May it please the court, my name is John Flannery, and it's my privilege to represent these chronic pain patients. The standard by which we measure a civilization is how we treat our own, and by that standard, we have done a miserable job, not just in this case, but in pain cases generally. We don't do anything to deal with the incalculable suffering that is foisted upon people, indeed by the careless acts such as the one in this one with Dr. Bakoff, by which they suspended his license. They did it based on what a doctor, a hired gun, had said who had been found not to be credible in an Ohio federal case. They did it based on extrapolating from 5 patients who basically didn't have any serious charge about their treatment until the government was involved. The DEA, by the administrator, suspended the license of Dr. Bakoff, forcing him to abandon his patients on the spot, even though abandonment is sanctioned in every state. The DEA did this. There was nothing the doctor could do about it. There was no notice or opportunity to be heard by the patients. And as a result, they were cast off to deal with things as they may.
Mr. Flannery, if I can ask you about finality here.
Yes.
So this court has jurisdiction under Section 877 only of final decisions of the administrator who's
Yes.
delegated the Attorney General's authority. And our court has said that that finality requirement is jurisdictional in the Doe case. So I'm wondering, why would an ALJ decision be a final action of the administrator in this
The
context?
final decision excluding a party, excluding a person of interest, someone with personal interest, is different than normal Article 3 judicial review. And that is the distinction, that 5 USC 555B entitles a person to apply as an interested person. A doctor who denies to a patient the ability to have a prescription, casting them into a life of suffering and perhaps suicide, is exactly the case that comes before 5 USC 555B.
Right. So it may well be it's reviewable, but there's not been a final decision of the administrator.
Well,
So why wouldn't the interveners have to seek such a decision from the administrator, either as an interlocutory matter or, on the merits with the rest of the decision?
well, there are a couple of interesting points about that. The 877 does say all final determinations, findings, and conclusions of the AG under this title shall be final and conclusive decisions to the matter involved, except that any person aggrieved by a final decision of the AG may obtain review of the decision in the U.S. Court of Appeals. Now, when we look at 555B, we see that it makes a couple of provisions. Let me get the statute in front of me, so I'm not doing it based on my memory. It grants persons a point of access to the court system with something less than Article 3 standing. In other words, it's not considered standing.
Okay, my question's not about standing, it's about finality.
Well, 5 U.S. then you have to reconcile it with 5 U.S.C. 704, which says agency action made reviewable by statute and final agency action for which there is no other adequate remedy in a court are subject to judicial review. That directly runs contrary to your concern. And it talks about in 704 something that is otherwise final, and nothing remains to be done in this case.
So there's something that can be done. the regulations, the DEA regulations provide that you can get an interlocutory appeal to the administrator. So the interveners here could have gone and said, you know, we were denied intervention. We're seeking an interlocutory review by the administrator. And if the administrator denied that or refused to hear it, then perhaps there would be final.
Judge Rose, I'm Judge Rowe, excuse me. I was putting you in the point of the ALJ, excuse me. Judge Rao, the thing we overlook here is, and I made something that may not be funny, that we rely on strangers. In this sense, we had no access to any of these records. We had no access to what is the court's final the ALJ's final decision. In fact, the service of that decision specifically excludes us. It includes only the government. It includes the two lawyers who are representing Dr. Bakoff. They do not include any intervener. We would have to divine what the ALG was doing in its secret proceedings to know what that decision was to appeal it in any way. Also in the statute, it makes provision under 5 U.S.C. 555 that any consideration of these matters should be prompt. This goes from, we filed our motion to intervene in November 22. We find out through the grapevine, the strangers who would let us know about it, that the court made a decision on May 2nd, 2023. From 2023 until today, there has, as best I can tell, I have no idea what the administrator did. I have no idea if anybody else appealed it. I can't agree or disagree. I can't join the suit. I have no way to participate in this sealed proceeding. And so I say there's no other adequate, excuse me, Your Honor.
But you did take an appeal, and I think the question is, if you could take an appeal to this court in order to ensure that you have a final decision of the administrator, who is the Attorney General's delegate in this matter, why wouldn't you, once you did obtain notice by fortuity, why isn't your step in order to finalize the agency decision to, I mean, the regulations and the statute are available to you. Those are not kept from you. Why isn't the step in order to get a final agency determination that you go, as Judge Rao has mentioned, on an interlocutory basis?
I would suspect that there are many secret DEA proceedings where precisely the disregard for pain patients occurs and no one can do anything about it.
But we're talking about this proceeding.
Well, in this
our
particular proceeding.
jurisdiction, whether we have jurisdiction, because whether we're sympathetic or not with your clients, we can only rule on something where we have jurisdiction.
Alternatives are that this court would endorse a proceeding in which you guess what's going on, you've been deprived to participate in, file an appeal without knowing what it's about in the normal case, and then waiting upon the administrator, while in this case, patients are suffering day by day. That's not a remedy. That's not law. That's not a process.
That's a responsive answer.
Well, I believe it is, Your Honor, because 5 U.S.C. 704 has to be reconciled. No other adequate remedy. And it says otherwise final. It is otherwise final. That decision denying intervention by my pain patients was otherwise final.
Can you explain the basis for Article 3 standing of your clients to come to this court?
We don't have Article 3 standing. That's the whole point. We have 5 U.S.C. 555, the right to intervene if you're an interested person, and being denied treatment and medicine that is necessary to your well-being seems to me to be a sufficient interest. No other party in this case could represent my clients. We were flying in the dark to try to find this out. If anything, it's a fundamental denial of due process or fair play. And that, it seems to me, is no other adequate remedy. What are we taught from the first year legal method about how we present an argument? We look at the case, we look at the authorities, forbidden to us. we weren't entitled to see it. We weren't entitled to see anything in the record. We weren't entitled to the search warrant that showed that they had doubts about this going forward. We weren't entitled to the list of when they were going to have hearings. We weren't entitled to any of those things. All of them were ignored. And between the denial of our intervention and the court's, the ALG's final decision, they contradict each other. And
I take it that you are not privy to the information that is relied on to proceed against Dr. Bakoff. That's confidential.
No, it wasn't in a limited sense. One, I had access to the search warrant, which required me to do some gumshoe work like I was a recovering federal prosecutor again. Two, I managed to get a subpoena that they issued. Three, when they outlined what it would be about, there was a set forth of what Judge Dr. Munzig had said, which has been challenged in an Ohio court. And so I had this, and I talked to each of the 5 who are named in the order to show cause, and they explained to me, and I made it part of our papers in the court before the ALG, that each of them was frivolous, and that because these are patients such that they're unable to actually sustain themselves unless they have this medication, the court didn't care. And the court cited, for the wrong reasons, different things, including it said that, well, if you have any problem without having a doctor, well, that's too bad. Maybe I could save a minute.
We'll give you a minute and reply.
Thank you. I appreciate it.
Ms. Gay?
Thank you for your time.
Good morning. May it please the court. Anita Gay on behalf of the respondents. The petition should be denied for 3 reasons. As Judge Rao pointed out, there is no jurisdiction under 21 USC 877 or 5 USC 704 in that this is not a final order. The order of the administrative law judge in the Dr. Bakoff proceeding, the correct and most efficient way for petitioners, if they had wanted to seek review of that, would have been to press for review under 21 CFR 1316.62, which provides for the ALJ to certify and issue to the administrator for a final determination that would then be reviewable under 877.
So you believe that would be reviewable if either the administrator made a decision on intervention or simply declined to take an interlocutory appeal at that point?
Yes.
It would be appealable.
Yes, and that is what is often done. If there is a suspension, an immediate suspension, then if they appeal that and the administrator denies it, then they come to this court or to another circuit court under 877. And we do not challenge the jurisdiction in those situations. But they did not do that. They did not do that in the motion to intervene. They did not do that in their motion to have an emergency stay of the administrative hearing. So the first issue is no jurisdiction. The second issue is that what they are asking for, the relief that they are requesting, is no longer available. It is now moot. The administrative hearing was conducted before the administrative law judge. The ALJ completed receiving testimony on January 24th, 2023, and then issued her report and recommendation to the administrator, findings of fact, conclusions of law. That was on May 5th of 2023.
But Ms. Gay isn't arguing that it's moot a bit of an overreach. I mean, the administrator has yet to act, and we've held in other circumstances that where an intervener is wrongly denied an opportunity to participate in administrative proceeding, that the court has the authority to remand for the agency to take account of the putative intervener's interests, reopen the record. And we could do that here as well if there were merit to this claim.
You're right, Judge Pillard. It would seem like at most what they could receive here would be an opportunity to supplement the record. But
doesn't that render it not moot?
That could render it not moot, but it would not render what they want to supplement with relevant. And the reason for that is in the order to show cause, there were 5 patients identified who were addressed by the expert who testified about how Dr. Bakoff deviated from the standard of care in California, how he repeatedly prescribed prescriptions that were not legitimate under 1306.04. Initially, there were 11 interveners. We now have 9, but the 9 patients do not overlap at all with the 5 patients who were at issue in the proceeding. And the DEA has held, and even other circuits have recognized, like in McKay versus DEA in the 10th Circuit, they recognized that evidence of lawful prescribing is entitled to minimal weight, and that even a few acts, a couple of acts of improper prescribing are sufficient to support a revocation or a denial or a suspension of a registration.
I don't question the second part of your statement, but is it really irrelevant what would happen to people who presumptively are legitimately being prescribed? I mean, for example, in Bonds versus Tandy, the Fifth Circuit talks about the Controlled Substances Act protecting the public's interest in the legitimate use of controlled substances and an interest in inhibiting the pernicious consequences to the public's health and safety of illegitimate use. So it's both. It's setting up a regime that is designed both to enable people to obtain lawful prescriptions from registered medical providers and to stem and punish where there's unlawful prescriptions. So to say that it's in some generic way not relevant what the fate is of lawful recipients of prescriptions seems to me not necessarily fully accounting for the interests of the CSA.
Well, what the prior courts have said, and in fact, what the ALJ said in the report and recommendation, which petitioners attached to the joint appendix, she did acknowledge that lawful prescribing is entitled to minimal weight in evaluating the factor 4 of the 823 factors for whether the registration is in the public interest, and that is the lawful prescribing and lawful handling of controlled substances. So it is entitled to some weight. I'm not saying that it's not, but the ALJ properly determined that in this instance, it would have been extensive, it would have been repetitive, and yes, there could be evidence of it, but it would not be the focus because it doesn't address the factors it doesn't refute the evidence of the unlawful prescribing to the 5 patients outlined in the order to show cause. And they could have been called as witnesses. I mean, that would be the method to present the testimony of the lawful prescribing. Dr. Bakoff chose not to present any testimony. He did not call an expert witness to counter the witness presented by the government. He did not testify to acknowledge his wrongdoing, to express that he knew what he had done wrong. He did stipulate that he had failed at record keeping because there were patient records in his garage in the storage unit. There were patient records scattered throughout his office.
So the putative intervener's statements were introduced in the case that Dr. Bakoff filed in California to try to restrain the suspension of his registration, but they were not included in the administrative record in this case.
Well, yes, Your Honor. In the Central District of California, 6 weeks after the immediate suspension order and order to show cause was served on Dr. Bakoff, he sought a TRO in the Central District of California, and he attached the 11 statements of the patients. Those were given to the administrative law judge, whether they are, so they should be in the record when it is certified by the administrator when there is a final order.
So they were given, meaning they were filed or proffered?
Yes. And yeah, so I think I merged 2 and 3 with saying that that it's now moot, but also getting to some of the merits of that the ALJ also, in addition to issuing an interlocutory order, but if the court does determine that a final order was issued, the issue did not, the decision denying their motion to intervene was properly made because they are not, their legal interests do not align with that of Dr. Bockoff.
It seems to me that the best case on standing for these petitioners is PDK Labs versus DEA, and I know it wasn't cited in the briefing. But we held there that a wholesale importer of a controlled substance had standing to challenge a DEA order that, as to which it was not a party. The order was restraining the importation, the sending in by foreign manufacturers to a PDK, which was a wholesaler of imported controlled substances. And I guess the question is, how would you distinguish that situation from this one? And I don't want to surprise you if it's not a case that you.
Oh, no. I'm aware of the PDK case as well as the Pennick case, which I believe Judge Henderson was involved in that opinion. And in those instances, there are certain provisions in the CFR, in the regs implementing the Controlled Substances Act statutes. And in there are specific provisions that do allow for intervention. Just like in the nuclear regulatory case that is cited by my friend, there was a specific provision for intervention. And what happened in PDK and in Pennick, if you are an importer of a controlled substance, and I think in Pennick it was for raw materials to create controlled substances. And so under the CFR, it specifically states if someone applies for a registration to be an importer, then notice is given, notice is published in the Federal Register, and notice is sent to everyone who has a similar registration. And that's what happened in PDK and in Pennick, is then those parties came in and objected to the new person. As I think in Pennick, there were 2 registrants who were able to bring in raw materials, and a third applied, and they objected to that, and they had a hearing to express why it was not, why the third company should not have it. So those are specific provisions that do allow for intervention, and that is how it is written in the code. There is no comparable position here. And if you think about it, it would be so unwieldy, and the ALJ did note this, saying that Dr. Bockoff, who did not want the interveners to intervene, Dr. Bockoff has a right to protect his due process interest in his license, in his certificate of registration to prescribe controlled substances. They do not have a due process right in this proceeding. But Dr. Bockoff did not want them. The ALJ noted that it would extend the proceeding. It would not provide the efficient review that he is entitled to, that the public is entitled to. But let's take it to its logical extreme. I mean, there are 2 million registrants in the US. Over half of those are practitioners, doctors, nurse practitioners. The other ones are pharmacies, distributors, manufacturers. So under my friend's theory, if there is a rule to show cause against any of the registrants, then in a pharmacy, every customer of the pharmacy would be able to come in and participate in the hearing. A physician, a practitioner, every patient would be permitted to come in. That is not what is contemplated by the Controlled Substances Act. It is set up to create the closed system so that there can be oversight and management to make sure that there's not diversion and abuse of controlled substances, and opening the doors to have anyone become involved, it would make the process untenable. It is also, I know there are several references in the brief to a star chamber or Orwellian conduct, and I confirmed with the DEA that the hearings are public. The pre-trial hearing is not, but that's akin to a pretrial discussion in chambers. It's not on the record. It's about scheduling, filing. But the actual hearing, especially now that post-COVID, they are.
Stop you. Okay, you're over.
Okay, I see I'm over my time and I rest on my brief and respectfully request that you deny the petition. Thank you.
You have 1 minute. Mr. Flannery, you have 1 minute.
Right. Try to restrain my Irish loquaciousness. My friend has accepted the principle that there can be collateral damage on behalf of efficiency throughout the system. I would point out that in this case, we have found and cited reasons why these proceedings were defective, and Dr. Bakoff's counsel said he wouldn't even talk to us. Section 1316.62 provides that rulings of the presiding officer may not be appealed to the administrator without the approval of the presiding officer below. So that was not going to be a remedy. As for it being moot, it is not moot because 5 USC section 706(1) provides as a remedy that one can remand the matter to be corrected. There's this question about not legitimate, as if we should take the findings of this questionable secret proceeding and give it the benefit of the doubt, notwithstanding the fact that the doctor who was their only expert on this matter is found to be entirely unreliable, so much so that there was a mistrial in Ohio federal court over this very issue. The, let's see, I got 14 seconds. The final thing I would say, Your Honor, is that Dr. Bakoff is a doctor who heals, he does not deal. And that we are, by upholding the practice of this ALJ, we are sanctioning the disregard of patients who suffer. I mean, really physically suffer because of these proceedings that hide in the shadows and do what they may. They can write a single sentence instead of the opinion that was written. But the opinion that was written that we managed to look at contradicts what they told us when they...
Mr. Flannery, finish your sentence. You're way over time.
I have. Thank you for your time. I appreciate it. And my clients do too.
Case number 22-5231, Barbara Kowal, appellant versus United States Department of Justice et al. And case number 22-5287, Barbara Kowal, appellant versus United States Department of Justice and Drug Enforcement Administration, Freedom of Information Request, PA units. Mr. Kelly for the appellant.
Morning, Mr. Kelly.
Good morning, Your Honors. May it please the Court. Matthew Kelly for Plaintiff and Appellant Barbara Kowal. Your Honors, as you know, the goal of FOIA is to open the federal government agencies and their records to public scrutiny. As the Supreme Court has said, it is a disclosure statute, not a withholding statute. The government has the burden to justify its withholdings. In this case, Plaintiff Appellant Barbara Kowal is seeking records from 3 federal law enforcement agencies to aid in the appeals of a federal death row inmate, Daniel Troya. Releasing these records will shed light on how DEA, FBI, and ATF performed their statutory duties in this capital murder case. Burdens of persuasion, production, and proof are key to both appeals. Kowal has met hers. The court should remand so that the government can be required to meet its burdens. I'd like to focus on just a few of the most important examples. First, I'd like to discuss the erroneous attempt to shift the burden on the public domain doctrine. Next, I will discuss how Kowal has met her burden to show that the inadequacies in the searches performed by the DEA, FBI, and ATF, and the government has not met its burden to show beyond material doubt that their searches were reasonable. Then, regarding the law enforcement privacy exemption 7C, I will discuss how Kowal has met her burden to show the public interest overrides any minimal privacy interest held by witnesses who testified at Mr. Troya's trial. Finally, I will highlight that the government has not met its burden to show that cooperating witnesses who testified spoke to agents under an express or implied assurance of confidentiality. First, for the public domain doctrine, a large portion of the information being withheld in this case should be released under the public domain doctrine. The public domain doctrine holds that the government can't withhold information that's public if it's in a judicial record, for example. The binding law of this circuit is that the information is in the public domain. It cannot be withheld even if a FOIA exemption would otherwise apply.
But it has to have been disclosed and maintained in a permanent public record, and it has to be an exact copy of what is in the public. And I'm not sure you've made that shown.
Judge Pillard, the standard is that it is information that is in the public domain rather than a document by document analysis. The burden that the plaintiff has in this situation is to identify specific information in the public record that appears to duplicate that being withheld. It's not an impossible burden. The plaintiff can't know precisely what is in the government documents that the government is withholding. So her burden of production in this matter is to show that there is specific information that appears to duplicate what apparently is being withheld. She has done so.
Is there a threshold showing in this case that the exhibits continue to be available in the clerk's office or on the public docket or elsewhere publicly?
I don't believe so, Your Honor, but I don't believe that that matters. For example, this court's holding in Catone versus Reno says that in that case, the issue was tapes that were played at a trial. This court said that once a tape was played at trial, it became part of the public domain, period, permanently.
But it had to be maintained. I'm looking at the same case. It has to be maintained in a permanent public record. And so I'm just wondering whether you have identified where the relevant material is maintained in a permanent public record.
It would be maintained in the clerk's office in the Southern District of Florida. Although I think that once... Have
you shown that? And if you have, I've missed it, so just point me to...
Yeah, I don't believe that we have, Your Honor. But I also don't think that the record-keeping practices of district courts should override the fact that once something is put forward, put into the public domain in a public trial, it is public.
But we have this other case, Students Against Genocide versus Department of State, 257 F3rd 828, in which we noted that even documents that were displayed in public but not released and permanently available, that those fall outside the public domain doctrine.
Mm-hmm. Students Against Genocide is very easily distinguishable. The records at issue in that case were photographs that the US UN ambassador showed in I believe a UN Security Council hearing. They were not made part of the record of that hearing and were not otherwise made public. That was not a federal trial. Obviously, the FOIA and the First Amendment and common law rights of access to records in this country don't apply to the United Nations. So that's a very different case, Your Honor. And as this court noted in Catone, because of the common law and First Amendment rights of access to judicial records, there is a public right of access to these records regardless. And that is another reason why they are in the public domain. The public has an independent right under the common law and the First Amendment to access these judicial records. So the facts inside them shouldn't be able to be withheld by the government under FOIA.
Mr. Kelly, I have a question about your argument about the adequacy of the searches, and in particular, the failure to search for the alias. The request is framed as seeking all documents, files, records pertaining to any investigation, arrest, indictment, conviction, sentencing, incarceration, and/or parole of Daniel Troya, AKA Homer. And I guess my question is there any reason to believe that any of the agencies would maintain a file or document relating to this individual's investigation, arrest, indictment, conviction, sentencing, incarceration, and/or parole under an alias?
The question is not necessarily whether they would keep a record specifically listed under that alias and nothing else.
Why not?
The issue is, did they do an adequate search that would capture all of the relevant records?
Right, but the relevant records, as your request defines them, are records of governmental action, investigative or arrest or prosecutorial action directed at this individual. And so is it possible that there is an arrest record or an investigation record that is kept under the name Homer, as opposed to one that is kept under the name of Daniel Troya?
Well, we've cited in our papers a number of cases in which the government did do searches using aliases.
Right, and there are situations in which an alias search will in fact turn up documents. And here, if it was any documents mentioning in any way Mr. Troya, AKA Homer, then it seems to me much more plausible that a text search would turn up something different. If he's, one of the people present when someone else is being surveilled. And so it's going to be the other person, it's indexed under the other person's name, but some guy named Homer is there. You could see a text search in ECF turning that record up, but that is not a record pertaining to an investigation, arrest, or the like of Homer. It's a record in which his name shows up, but it's pertaining to an investigation of someone else. So I'm just saying that the way that you framed the request, I'm trying to imagine how a search using the alias could plausibly turn up documents that weren't turned up under the name search.
Well, I think that the law is that the government has to interpret FOIA requests broadly. And if you narrow it to kind of parsing the word pertaining to, yes, perhaps that would limit the search to documents that are kind of indexed to that person and indexed to that person rather than other documents indexed to other people that might mention either Mr. Troya or him by his alias of Homer. And it's that second category of documents that we believe should be part of this request. Perhaps the request was not worded as artfully as it should have been. But the fact remains that the government has an obligation to interpret requests broadly and not narrowly. And we don't believe that that was done.
So are you asking us to drop any investigation, arrest, indictment, conviction, sentencing, incarceration, and/or parole of? Is that the lenience that you want in terms of how we read the request?
Not drop that from the request, but interpret it broadly as being seeking records pertaining to that individual, whether it's indexed under his name or not.
Mr. Kelly, why isn't the solution to that to just simply file a different FOIA request, a second FOIA request for that precise information?
That's certainly something that could be done, Your Honor. I think that in the interest of efficiency,
Is it
that
really
would,
efficient to come to court and litigate all of this before bringing a second request to the agency? Maybe that would simply just turn up what you're looking for.
well, I think that, as you know, there are a number of issues in this case. And I think litigating through the issues indeed, it's two consolidated cases. Litigating through all of these issues, once is better than multiple times. And I think that's one of the reasons why the government is required to interpret FOIA requests broadly, because we don't want to have to be litigating these things again and again and again. I don't think that's a good use of the government's resources or the judiciary's resources.
I mean, broad is one thing, but, simply ignoring the limitations that a party puts on its request in terms of what it's looking for. I mean, if a party seeks certain type of information, I don't think the government is required to boil the waters in order to, interpret it to mean anything that might refer to an individual mentioned in the FOIA request. I mean, that doesn't seem efficient for the government or for taxpayer resources in responding to FOIA requests.
Yeah, true. And we're not asking the government to boil the ocean, Your Honor. But what we are saying is that in this case, the request, I think, reasonably interpreted broadly as the law requires, would pertain to those records that are not indexed directly under Mr. Troya's name. And there's another problem with the searches too, and it's, I think, a larger one, and that's the fact that none of the searches turned up any multimedia documents, no photographs, no recordings, no audio recordings, no video recordings, nothing like that. And despite the fact that the request specifically requested those kinds of materials, and in the court below, Ms. Kowal provided a list of 200 such materials that the judge acknowledged reading in the DEA case, and said that it provided some support for the idea that the search wasn't diligent enough because it did not turn up these whole entire categories of types of records. But the court below said that just because Ms. Kowal has them doesn't mean that the DEA still has them. But that begs the question, does the DEA still have them? The judge's question assumed that DEA did in fact have them at some point. And only the DEA can answer that question. They're the agency that holds the documents that are being withheld. We can't know what the agency is, and I think that the case should be remanded, among other things, to determine whether the fact that there were no multimedia files produced shows that the searches were inadequate, and we believe that that is the case. If I can move to, I see that I am in my rebuttal time, and unless Your Honors have any other questions, I will turn it over to the government.
Mr. Steinman.
May it please the court, Jeremy Simon with the U.S. Attorney's Office on behalf of the appellees. I would like to just address the two principal issues that counsel has addressed to the court just now. On the public domain issue, the principal argument concerns the playing of these recordings in court. But the document they're seeking to obtain under the public domain exception based on that those recordings is not court recordings, or not tapes of recordings, or even a transcript of recordings. It is a narrative summary of a case initiation that is a compilation of information from a variety of sources and techniques. And the court can see that description in the Vaughn Index in the appendix in 225231, at the appendix 215 to 216, and the declaration that discusses that is at appendix 190, paragraph 15. And then there's also some other paragraphs that talk about other FOIA exemptions being asserted over the same information, which again demonstrates that this is a compilation of information from a variety of sources. So the exactitude requirement of the public domain doctrine does not apply. In terms of the other sort of iteration of the public, what they call public domain, are the names appearing in the names of people who testified at trial. That is addressed very clearly by this court already in the Crew versus DOJ case, 854 F3D 675. That's really not a public domain argument. The court in that case very clearly said that individuals who testify at trial still have a privacy interest in not being connected to specific documents in a criminal investigative file. Also, just want to emphasize the public domain doctrine is a narrow exception. And therefore, a very specific showing is needed by the case law in order to for the plaintiff or the requester to meet their burden there.
Mr. Simon, I have a question about the government's arguments under Exemption 7D regarding confidential sources. And the Supreme Court in Londano rejected kind of categorical, certain witnesses are going to be treated as having implicit assumption of assurance of confidentiality. How does that not defeat the government's position here?
I believe, Your Honor, that Londano, in that case, I believe the government had said anyone who speaks to the FBI is entitled to implicit confidentiality. And the Supreme Court said that is not sufficient, but the Supreme Court recognized that there could be certain categories of cases where the implication would be established. And in this court's case, Hodge versus FBI, the court held that the violent nature of a crime where there's a threat of reprisal, which this crime fits squarely. It's a murder of a family on a roadside in connection with overarching drug operation, violent drug operation. So when you have that type of underlying crime that is at issue, I think Hodge establishes that there is an implied confidentiality. In terms of the search regarding the overlooked record issue that counsel raised, just to note, first of all, that document, the list, only was provided in the DEA case. It wasn't provided in the ATF/FBI one that's under 225231. But aside from that, the list is in the appendix for the DEA case at appendix 129 to 33. And if you look at that list, counsel or Kowal has said it's 200 overlooked records, but there's nothing to indicate that they were ever in the possession of DEA. And if you look at the titles of the types of documents that are listed there, I think only a handful have DEA in the title. Many of them relate to prison calls or the activities of state and local law enforcement. The court may recall there were approximately 4 state and local law enforcement entities involved in this investigation. And so they have not met the burden to show that to the extent anything could be established from there is that there was just a handful of documents with the DEA in the title. And the court's case law.
I'm sorry, you said there were 4 state and local law enforcement agencies. In other words, in addition to the 3 defendant agencies in this appeal, there was a state law enforcement agency involved?
In the investigation of this crime.
So is the implication that the multimedia information that they're seeking and that they're pointing to as overlooked documents that call into question the reliability of the search, is your implication that those were generated and are maintained by a state agency?
That is certainly a possibility. And I think the titles of those documents, a lot of them refer to detectives from the various state and local law enforcement agencies, would certainly create that implication. But ultimately, it's the plaintiff's burden to show that there was some indicia on these documents to suggest that the source was DEA or the other agencies.
So wasn't there, though, an exhibit list in the federal case that listed some or more of these documents? I mean, I thought that was was evidence that these are in the possession of the federal officials.
Well, I think the document I'm referring to, Your Honor, is at Appendix 129 to 33 in 225278, I believe is the case number. And that's the list that the district court understood to be Kowal's list of the so-called overlooked materials that they allegedly have in their possession from their criminal discovery file that were not produced.
But then there's an assertion, I believe, that there was an exhibit list on which some of these documents appeared.
That, I believe, Your Honor, pertains to the public domain argument where the Kowal was trying to suggest that documents had been entered in evidence as exhibits, and therefore the government has no basis to withhold them, even though they would otherwise be exempt because they relate to third parties. And that was, I believe, in the context of the public domain argument, not in the context of the search. If the court has no further questions, we would just rest on our briefs and ask that the judgment below be affirmed.
Thank you.
I'd like to start with government counsel's citation to the crew case. The one cited to is essentially kind of the second iteration of that case. And what the counsel for the government did not mention was that in that case, this court held that the presumption against disclosure of the names of third parties in law enforcement documents does not apply to people who have been publicly identified, including via testimony in open court, as having been charged, convicted, or otherwise implicated in a crime. That's at 854 F3rd, 682. So, even the case that they're citing shows that, the privacy interests that people who testify at trial, for example, are minimal. They're not zero, but they are minimal, and they are overcome by a showing of public interest in the records that are being withheld. And we have shown that the interest here is showing how these law enforcement agencies perform their statutory duties in a capital case. Secondly, counsel for the government acknowledged that some of the multimedia records on the list provided to the court do have indications that they were from the DEA. That's enough. That's not zero. I would submit that that is enough to remand and require the government to do the diligent search that it should have done in the first place. We're not, we don't have the burden to show, by name and number every single document that they didn't provide. Our argument is they did not provide an entire category of types of materials, and that is evidence that the search itself was inadequate. I see my time has expired. Thank you, Your Honors, very much.